Hello friends, as part of my video lecture series, today I would like to explain maintenance of wives, children and parents as under Code of Criminal Procedure 1973. The provisions related to maintenance of wife, maintenance of children and maintenance of parents are specified under sections 125 to 128 in chapter 9 of Criminal Procedure Code 1973. Here, for the purpose of chapter 9 of CrPC, maintenance includes provision for food, provision for clothing, provision for residence, provision for education and provision for medical attendance and treatment of all the wives, parents and children. Maintenance includes reasonable expenses for marriage of the unmarried daughter. The word maintenance is not defined under the Code of Criminal Procedure 1973, but the term maintenance is defined under section 3B of the Hindu Adoptions and Maintenance Act 1956. The same definition applies to the Code of Criminal Procedure 1973. For the purpose of maintenance under this chapter, that is chapter 9, minor means a person who, under the provision of the Indian Majority Act 1875, is deemed not to have attained his majority. Minor is a person who is not completed the age of 18 years. Simply, minor is a person who is not a major as per Indian Majority Act 1875. The word minor is not defined under Criminal Procedure Code 1973. We need to use the definition of the word minor, which is defined under the Indian Majority Act 1875. Next, wife includes a woman who has been divorced by the husband, or wife includes a woman who obtained a divorce from her husband. If she has been divorced by her husband, she is treated as a wife. If she obtains the divorce from her husband, if he obtains the divorce from her husband, she becomes the wife for such man. Wife includes a woman who has been divorced by her wife and has not remarried. Wife includes a woman who has obtained a divorce from her husband and has not remarried. This is the duty of every person to maintain his wife, to maintain his children and to maintain his aged parents. The wife, children and aged parents are unable to live on their own, then the concept of maintenance applies on him. The person is liable to pay the maintenance to his wife, children and aged parents if the wife, children or aged parents are unable to live on their own. If they are unable to live on their own, then maintenance is the right. They can seek the maintenance from, a wife can seek the maintenance from her husband, subject to certain conditions. A child has a right to get the maintenance from his father, subject to certain conditions. Aged parents have a right to obtain maintenance from their children, their son, even from their daughter, subject to certain conditions. One of the condition is they must be the persons who are unable to live on their own. If they have no sufficient means for their livelihood, then they have a right to get the maintenance from such husband, such father, and such son. Chapter 9 of Criminal Procedure Code 1973, containing sections 125, 126, 127 and 128. These sections lay down the provisions related to maintenance of wives, maintenance of children and maintenance of parents. According to section 125 subsection 1, husband, father, son or daughter, these are the three categories of persons are liable to pay the maintenance to wife, children and parents respectively. A husband is liable to pay the maintenance to his wife. A father is liable to pay the maintenance to his children. A son is liable to pay the maintenance to his parents. A daughter is liable to pay the maintenance to her parents. Here, husband, father, son or daughter are the persons liable to pay the maintenance to the wife, children and his or her parents respectively. Next, persons entitled to maintenance. In the previous slide, we discussed the persons liable to pay the maintenance. In this slide, we are going to discuss the provisions related to persons entitled to maintenance. Just now we discussed wife, children and parents have a right to entitle the maintenance from the husband, from the father, from the son or daughter respectively. These three categories of persons, wife, children and parents, have a right to entitle the maintenance. Here, in the coming slides, we will discuss when a wife is entitled to maintenance, when she is not entitled to maintenance, whether a legitimate and illegitimate son is entitled to obtain the maintenance, whether a daughter of the legitimate or illegitimate, whether a legitimate or illegitimate daughter has a right to entitle the maintenance from her parents, from her father, whether the mother and father have the right to entitle the maintenance. Here, as we know, it is very clear that the wife, children and parents have a right to entitle the maintenance subject to certain conditions. These conditions are well defined, well quoted under chapter 9 of Code of Criminal Procedure from sections 125 to 128. Let us discuss when the wife is entitled to maintenance. Before going to know such conditions, it is better to know the remedies available for the wife in order to entitle the maintenance from her husband. A Hindu married woman who has been separated from her husband on reasonable cause, entitled to claim maintenance under the following provisions. There are three important legislations in India which deal with maintenance to wife. The first important legislation is Hindu Adoptions and Maintenance Act 1956. The name of the legislation itself says that a wife, even though she has sufficient means for her livelihood, has the right to entitle the maintenance as under section 18 subsection 1 of Hindu Adoptions and Maintenance Act 1956. According to section 18 subsection 2 of Hindu Adoptions and Maintenance Act 1956, a wife who is living in the same roof along with her husband is entitled to maintenance. The wife who has sufficient means for her livelihood can entitle the maintenance under section 18 subsection 1 of Hindu Adoptions and Maintenance Act 1956. A wife who is living in the same roof along with her husband, she has not been separated from her husband, she has been living in the same roof along with her husband, can entitle the maintenance from her husband as under section 18 subsection 2 of Hindu Adoptions and Maintenance Act 1956. This is the first remedy available for the wife in order to obtain the maintenance. It is available only for Hindu women. The second remedy is maintenance to wife under Hindu Marriage Act 1955. According to section 24 of Hindu Marriage Act 1955, during the pendency of the application for divorce or judicial separation or divorce by mutual consent, the wife has a right to obtain the maintenance from her husband. This is a temporary relief available for the wife as well as for the husband against his wife. The temporary relief which is available for both the spouses or either spouse, it is available for wife or the husband during the pendency of the application as a temporary relief, as a interim relief, who has no sufficient means to live on his own or on her own. Hindu Marriage Act 1955 provides, or it confers, the right to maintenance for both the husband as well as wife. If the husband has no sufficient means to live in his own, then he can file an application for maintenance from his wife. If the wife has no sufficient means, then she can file an application for interim maintenance against her husband under section 24. This is known as pendenti lite. Section 25 of Hindu Marriage Act 1955 confers the right to maintenance for either spouse as a permanent relief. The court, on the basis of the satisfaction, after considering all the grounds, the court may sanction the permanent alimony or maintenance. This right is available for either spouse. It is available for husband as well as wife who has no sufficient means. It is the second remedy available for Hindu wife and also for Hindu husband. The first remedy, Hindu Adoptions and Maintenance Act 1956, confers a right for maintenance only for Hindu wife. The Hindu Marriage Act 1955 confers the right to maintenance for Hindu wife and Hindu husband as under section 24 for interim relief, under section 25 for permanent relief. Section 125 of Code of Criminal Procedure 1973 confers the right to maintenance for not only to a woman, a wife, but also for the children and parents. That is the difference. A wife can entitle the maintenance as under Hindu Adoptions and Maintenance Act 1956, or as under Hindu Marriage Act 1955, or as under Code of Criminal Procedure 1973. These three remedies are available for a Hindu wife. Irrespective of the religion, Section 125 of CrPC 1973 confers the right to claim the maintenance to all wives, all children and all parents, the wives of any religion, the children of any religion, the parents of any religion. It is not a curative measure, it is a preventive measure specified under Criminal Procedure Code 1973. Let us discuss when a wife is entitled to maintenance. There must be a legally vetted marriage between the wife and husband as per their religion, as per the rights and customs of a particular religion. There should be a legally vetted marriage. If the marriage is a void marriage, then she cannot entitle the maintenance. It is the first essential element. The disqualification of the first essential element leads to disqualification to entitle the maintenance. The second essential is husband has neglected or refused her to maintain, or wife has been separated from her husband on reasonable cause. There must be a legally recognized marriage as per a specific religious customs and rights. That is the first essential element. Then the husband has been neglected her to maintain, or the husband has refused her to maintain. This is the second condition. Or if the wife has been separated from her husband on a reasonable cause, it is the second essential element. This is the first one. This either this one or this one. This should be fulfilled. Either this one or this one should be fulfilled as a second condition. The first one is a legally vetted marriage as per the customs and rights of a particular religion. Then either the husband has neglected or refused her to maintain, or wife has been separated from her husband on a reasonable cause. This is the second condition. Either this one or this one. The third one is she must be in a position to not to maintain herself. If she is unable to maintain herself, then she can file an application for maintenance. This is the third condition. And the fourth condition is husband has sufficient means. If there is a valid marriage husband has neglected her to maintain, or husband has refused her to maintain, or wife has been separated from her husband on a reasonable cause, she is unable to maintain herself, she has no means for her livelihood, and the husband has sufficient means of income. If all these conditions are fulfilled, then a wife is entitled to maintenance from her husband. Let us discuss the conditions when a wife is not entitled to maintenance. When a wife is living in adultery, then it becomes a disqualification for a wife to entitle the maintenance from her husband as per section 125 of Criminal Procedure Code. If the wife has sufficient means for her livelihood, if she is doing a particular job, if she has sufficient means for her livelihood, then she is not entitled to maintenance as under Criminal Procedure Code 1973. If the wife refuses to live with her husband without sufficient reasons, then she cannot entitle the maintenance from her husband. If the husband has contracted marriage with another woman, or if her husband keeps a mistress, it shall be considered to be a just ground, a reasonable ground for his wife to refuse to live with her husband. She must refuse. If she refuses to live with her husband without sufficient reasons, without reason, if she refuses to live with her husband with a reasonable ground, she can entitle the maintenance. If she refuses to live with her husband without sufficient reasons, she cannot entitle to maintenance as under section 125 of Code of Criminal Procedure 1973. Living separately by mutual consent. When there is the condition that both the husband and wife are living separately by mutual consent, then she cannot entitle to maintenance as under Criminal Procedure Code 1973. If she is a divorced woman, if she remarriages after the divorce, then she cannot entitle the maintenance from her ex-husband. These are the conditions when a wife is entitled to maintenance. These are the conditions when a wife is not entitled to maintenance as under section 125 of Criminal Procedure Code 1973. Okay, let us have a quick look on the important judgments on maintenance to wife. In Muhammad Ahmad Khan versus Shabano Begum, in this case, the apex court of the biggest democracy held that section 125 of Criminal Procedure Code is applicable to all women, all wives, including the Muslim woman. Then, in order to nullify the verdict of the Supreme Court, then central government enacted a new legislation called the Muslim Women's Protection of Rights on Divorce Act 1986. It came into force from 1986. As per the provisions of the Muslim Women's Protection of Rights on Divorce Act 1986, a Muslim woman cannot entitle the maintenance from her husband after the period of iddat. Then in 1992, in Muhammad Umar Khan versus Gulshan Begum, in this case, the court held that the Muslim Women's Protection of Rights on Divorce Act 1986 allows a Muslim woman to invoke the relief, that is, the relief is maintenance from her husband, under section 125 of CrPC, is only available to her if her husband gives the consent to such maintenance. If a Muslim husband gives the consent to give the maintenance to his wife, on the basis of his consent, a Muslim woman can entitle the maintenance. This was the verdict in Muhammad Umar Khan versus Gulshan Begum case in 1992. But in Iqbal Banu versus State of Uttar Pradesh in the year 2007, it was held that a neglected or deserted woman, especially the Muslim wife, a neglected or deserted Muslim wife can claim the maintenance under section 125 of CrPC without consent from her husband. This is the present status of maintenance to Muslim wife as per Iqbal Banu versus State of Uttar Pradesh from the year 2007. If a Muslim wife is neglected or deserted, can claim the maintenance under section 125 of CrPC even without the consent from her husband. In Rajesh R. Nair versus Meera Babu, Kerala High Court held that an agreement in which a wife waives her right guaranteed under section 125 of CrPC is treated as an agreement against public policy. If the wife relinquishes the right guaranteed under section 125 of CrPC for maintenance by making an agreement, by entering into an agreement with her husband, then such agreement is treated as an agreement against public policy. Hence, that is not a valid agreement, even though if she relinquishes her right guaranteed under section 125 with an agreement, she can again file an application for maintenance. This is no bar, that is making an agreement by wife in order to waive her right guaranteed under section 125. Next, in Sayanna versus Lakshmi Bai, in this case, it was held that wife whose marriage is void cannot entitle for maintenance. Just in the previous classes, we discussed that a wife who is legally wedded with a person can entitle the maintenance under Criminal Procedure Code 1973. If the marriage is void, then she cannot entitle the maintenance. In Tannichalam versus Dakshayani, it was held that past adultery is not relevant. Next, we have discussed about the first category, that is wife, when a wife is entitled to maintenance and when a wife is not entitled to maintenance. Coming to the second category, that is children. The children can entitle the maintenance under section 125 of Criminal Procedure Code 1973. Here the children includes the son as well as daughter. Both the legitimate and illegitimate sons can entitle the maintenance from their father. Legitimacy is not an important criteria for maintenance with regard to the children as under section 125 of CrPC. Both the legitimate as well as the illegitimate children have a right to get the maintenance from her husband. Let us discuss the conditions. If the son, whether he is legitimate or illegitimate, is minor, without any conditions, he has a right to entitle the maintenance. If the son, whether he is legitimate or illegitimate, is major, he cannot entitle the maintenance. But if the major son, whether he is legitimate or illegitimate, has physical disability or mental disability, he can entitle the maintenance from his father. Here, minor son, without any conditions, have a right. A minor son has a right to entitle the maintenance without any conditions. A major son can get the maintenance from his father subject to certain conditions. The conditions are, if the major son has physical disability, he can entitle the maintenance, or if he has mental disability, he can entitle the maintenance. The major son without physical disability or without mental disability cannot entitle the maintenance as under section 125 of Criminal Procedure Code 1973. Next, this part is over. Now the second part. Daughter, whether legitimate or illegitimate, can entitle the maintenance as under section 125 of the Act 1973. The daughter of any age, the age is not a criteria for maintenance in case if she is unmarried daughter. Unmarried daughter, irrespective of her age, has the right to entitle the maintenance. A married daughter is no right, she has no right for entitlement of the maintenance from his father. Once she get married, then she can file an application for maintenance if she wants. She can file an application for maintenance from her husband, not from her father. Hence, married daughters cannot entitle the maintenance from her father. Unmarried daughter of any age can entitle the maintenance from her father. This is related to when the children entitled to the maintenance from their father. Let us have a quick look on the important judgments on maintenance to children. In Sri Bhagavant versus Shamdevi, it was held that no maintenance can be claimed for unborn child. In TPSH Sava Saroja versus TPSH Sasina Thani, it was held that unmarried daughter who is living away from her widowed mother cannot claim the maintenance. In Nur Sabha Khatun versus Muhammad Qasim, in this case, the Supreme Court held that the children of Muslim parents has the right to entitle the claim of maintenance. In Ved Prakash versus Leena Kahar and another, it was held that parents-in-law not liable for maintenance to the widowed daughter-in-law and grandchildren. Now, the third category of persons who are entitled to maintenance. We have discussed when the wife is entitled to maintenance, when a children is entitled to maintenance. Now it's the time to discuss when the parents have a right to entitle the maintenance from their children. Parents includes mother and father. It is a social and pious obligation to maintain the parents. A father or mother unable to maintain himself or herself is entitled to claim maintenance from his wife from his son or her son. Here the mother and father denotes different kinds. The natural father and natural mother can entitle the maintenance from her son. The adoptive father and adoptive mother can entitle the maintenance from their adoptive child, from their adoptive son. A stepfather and stepmother cannot entitle the maintenance. There are certain judgments subject to conditions. If the stepmother has no child, no son, no daughter, then she can also claim the maintenance from her stepson. It was held in certain cases. However, in general, natural father, natural mother, adoptive father and adoptive mother can entitle the maintenance. The stepfather and stepmother cannot entitle the maintenance. Let us have a quick look on important judgments on maintenance to parents. In this case, a Hindu stepmother is not entitled to claim maintenance from her stepson. In Vijay Manohar Arbat versus Kasirao Rajaram Savai, in this case, it was held that the daughter, whether married or not, liable to maintain her parents. Both the son as well as daughter are liable to maintain their parents. Next, let us have a quick look on all the provisions related to maintenance. Wife is entitled to maintenance under these conditions. A minor son is entitled to maintenance. A major son who fulfills these conditions can entitle the maintenance. A daughter who is unmarried can entitle the maintenance. A married daughter cannot entitle the maintenance. The natural father and natural mother, the adoptive father and adoptive mother can entitle the maintenance. Stepfather and stepmother cannot entitle the maintenance. Next, important judgments on maintenance to parents. We have already discussed these two cases. Coming to the next one, in Miss Vijaya Manohar Arbat versus Kasirao Rajaram Savai, maintenance from the daughter if she has sufficient means of her own independently and court satisfaction, she is liable to pay the maintenance to her parents. In Vijaya Lakshmi versus N. Ramanadam, in this case, it was held that a childless stepmother can claim maintenance from her stepson. In Hardev Singh versus State of Uttar Pradesh, it was held that Sadhu, a yogi who renounces the world, is liable to maintain his wife and children. Next, section 126 deals with the procedure for maintenance. How to claim the maintenance is specified under section 126 of Criminal Procedure Code 1973. An application for maintenance under section 125 of Criminal Procedure Code can be instituted against the person in any district where he is where he or his wife resides, where he or his children resides, where he or his parents reside, where he last resided with his wife or his parents, or with his children, as the case may be, with the mother of the legitimate child. It speaks about the jurisdiction. The maintenance application has to be made before the magistrate of first class. The magistrate of first class is the competent court for accepting the application for maintenance. There is no limitation for maintenance application. The law of limitation, the Limitation Act, does not apply on the maintenance as under Criminal Procedure Code 1973. Maintenance petition should be disposed of within 6 months. All the evidence in maintenance proceedings shall be taken in presence of the person or in presence of his pleader against whom the maintenance application is filed. If the person willfully avoids or neglects his attendance, the magistrate may proceed and set ex parte such person. He orders certain amount of maintenance. The magistrate can pass the orders for certain amount of maintenance if the person willfully avoids or neglects his attendance to the court. Any order so made may be set aside for good cause if it is made within 3 months. So you can file a set aside petition within 3 months on good cause. Next, alteration, cancellation, and cancellation of maintenance. The magistrate has a power to alter and to cancel the amount of maintenance or interim maintenance fixed by him earlier to the wife, children, or parent, as the case may be, depending upon the circumstances of the case. Depending upon the circumstances of the case, the magistrate can increase the amount of maintenance if the husband gets the promotion, if he gets a salary hike on application from his wife or children or from parents. The magistrate, depending upon the circumstances of the case, if he satisfies with the averments stated by the wife, parents or children against such person, she can increase the maintenance. If there is a salary cut on application, the magistrate can decrease the maintenance to the child, wife or parents. Even if they violate certain conditions, an unmarried daughter has the right to obtain the maintenance from her father. Once she gets marriage, then on application from the father, the magistrate can cancel the amount of maintenance to the daughter once she gets married. If the divorced wife remarries with some other person, then on application from the ex-husband, the magistrate can cancel the amount of maintenance. Here, the magistrate has a power. He can alter, that means he can increase or decrease the maintenance or inter-maintenance. He can cancel the amount of inter-maintenance or maintenance to the wife, children or parents, depending upon the circumstances of the case. it was specified under section 127. Next, section 128 speaks about enforcement of order of maintenance. An application has to be made to the magistrate within 1 year if the order of maintenance is disobeyed. If the person against whom an application for maintenance is filed disobeyed the orders of the court, then if such matter is brought to the notice of the magistrate in the form of an application, then the magistrate may issue the warrant, or the magistrate will fine, the magistrate will impose the fine on such person, or the magistrate can impose the imprisonment, which may be extended to 1 month or until payment. This is the enforcement of order of maintenance, which is specified under section 128. If the person disobeys the orders of the magistrate, then the magistrate has a power to issue the warrant, or to impose the fine, or to send such person to imprisonment that may be extended to up to 1 month or until the payment. Thank you, friends. For queries, feel free to contact me using the email ID subhanbande@gmail.com. For latest updates on various law topics, subscribe to my YouTube channel using this link